Yeah, my lord, leave to mention a matter. My lord, leave to file without certified copy.
When was the order passed?
The order was passed on the 29th
of August?
My lord.
Yes.
No, on the 9th of September. I apologize.
Granted,
9th
granted.
of September. Grateful.
My lord, with kind leave, my lord, this is an appeal against an ex parte order where the injunction has been refused. My lord, there is extreme urgency because it pertains to the CAB elections, Cricket Association of Bengal.
File it, sir. File it.
My lord, it's already filed and numbered. My lord, I'm just humbly praying that let it be listed tomorrow. It's an assigned matter, my lord.
This is the which side? Appellate side.
Appellate. Great.
Item number 1.
My lord, I have checked up. My lord, this appeal is not maintainable. My lord may pass appropriate order. I couldn't find anything.
देखिए
Last year, I put a response read by Mr. Gemado.
Disclosure of non-document. Not permitting additional disclosure of documents.
Oh, I see. Disclosed documents. Issue. Would you like to withdraw it? We can permit it.
I wanted to contact the advocate on record, but I couldn't, my lord.
I see.
So that's why.
देखो, this appeal is directed against a judgment and order dated September 17, 2024, passed by a learned judge of this court in IA number GA-COM 5 of 2024, filed in CS-COM 122 of 2024. Being a suit filed by the appellant. Suit filed by the appellants.
My lord.
Suit filed by the appellants herein. Stop. Paragraph. The appellants filed the application for praying for leave to disclose certain documents mentioned in paragraph 5 of the application. Stop. The learned single judge dismissed the application. Hence this appeal. Paragraph. We are afraid that this appeal is not maintainable on a reading of on a conjoint reading of Section 13 of the Commercial Courts Act, 2015, and Order 43, Rule 1 of the Code of Civil Procedure, 1908. Stop. Paragraph. Accordingly, without addressing the merits of the case, we dismiss the appeal and the connected application.
My lord, the appellant may be granted liberty to pursue appropriate remedy.
Paragraph. This order will not prevent the appellants from
That is always there, my lord. That is always
from
there.
pursuing any other remedy that they may have in law.
Grateful to my lord.
Lordship, in this matter also, the question of maintainability was raised by the opposite side. Lordship, I am led by Mr. Kuldeep Malik in this matter. Lordship,
Not maintainable is not maintainable.
Lordship, I want to place one coordinate bench judgment of your Lordships.
What was the kind of order?
Your Lordship, this appeal is arising out of the application filed against the order passed in judgment on admission. Judgment on admission. May I? Under section.
অর্ডারটা দাও আগের দিনে নেই কোনো অর্ডার নেই রেকর্ড করেছিলাম একটা অর্ডার so the plaintiff has come up against rejection of the rejection তো হয়নি Judgment about arbitration. Come on. Yes, we remember. Two applications were dismissed by
Your
the
Lordship,
learned
same
judge.
order.
Yes, place the decision.
The decision is your, may I hand it over? Or it
হ্যাঁ
Your Lordship,
সাহেবের সই বাকি আছে সই করে দাও সাহেব
Your Lordship, first, Your Lordship, I may take Your Lordship to Section 13 of the Commercial Courts Act. Section 13 of Commercial Courts Act. Before going to the judgment, if Your Lordship can refer to Section 13 of Commercial Courts Act once. Lordship, para 4 of this judgment. Para 4 and 5.
How is this applicable?
Lordship,
How is this applicable to the facts of
Your Lordship, kindly come to Section 13 once of the Commercial Courts Act. Section 13, subsection 1A. Any person aggrieved by the judgment or order of commercial court at the level of district judge exercising ordinary civil jurisdiction, or as the case may be, commercial division of a high court, may appeal to the commercial appellate division of that high court within a period of 60 days from the date of judgment or order, provided that an appeal shall lie from such order passed by the commercial division or a commercial court that are specifically enumerated under Order 43 of the Code of Civil Procedure 1908 as amended by this Act, and Section 37 of Arbitration and Conciliation Act 1996. Lordship, I am on this second proviso. Lordship, this matter was in respect of Section 37 of Arbitration Act.
Yes.
Where Your Lordship has held that this the maintainability point goes, Your Lordship, in paragraph 5. Since the same issue was raised before Your Lordships also, that this appeal was not maintainable. If Your Lordship allows me, Your Lordship, I am led by Mr. Kuldeep Malik. Your Lordship, on the next occasion, Kuldeep Malik will apprise Your Lordship on this issue.
What has been held in paragraph 5? Please read again.
Paragraph 5. May I? One should decide the applicability of the order from the substance of the order. The section under the order is passed is not material. In Arbitration and Conciliation Act 1996, the right to appeal is identified in relation to the section under which an order is passed. The appealability of an order is also to be appreciated in the context of the subject matter.
Yes.
In my opinion, if the appellant had succeeded in its application before the learned single judge, the effect would have been adjustment of a part of award, resulting in its reduction by setting of the counterclaim against the award. In that event, part of the award would have stood set aside.
What does
That,
this mean?
Your Lordship, in this
It
judgment,
amounts to part of setting aside of the
part of
award.
setting aside the award.
That would be appealable under section 37.
37.
Hence, this appeal was entertained. So, how is this helping you here?
Lordship, in our case, Your Lordship, partly, Your Lordship, the application was allowed. May I place my the impugned order, Your Lordship?
Your application has been rejected.
Rejected, but Your Lordship,
You wanted judgment on admission. That application has been rejected. Where is the question of part?
but Your Lordship, they have filed one more application,
Which was also
Their
rejected.
which was
application
also
has been
rejected.
rejected. So for that does not give you a cause of action to say that your application has been partly allowed.
They have been well advised. They have been well advised not to come up in appeal. What is it? Issue.
Then in that case, Your Lordship, passes necessary.
Yes.
Yes. appeal is rejected against judgment in order to reject
যেখানে আপনার arbitration act 37 এ
25/2025, whereby
partly allow হয়েছে
the plaintiff's application under Order 12, Rule 6 of the Code of Civil Procedure, praying for judgment on admission, has been rejected. Plaintiff's application under Order being plaintiff's application under Order 12 being GA number 3 of 2020, bracket paragraph. By the same order, the defendant's application being GA within bracket com 4 of 2024, filed under Order 7, Rule 11 of the Code of Civil Procedure 1908, seeking rejection of plaint and dismissal of the suit, has also been rejected. The plaintiff, paragraph. The plaintiff has come up in appeal, feeling aggrieved by the rejection of its application under Order 12, Rule 6 of the Code, being GA 3 of 2023. Full stop. Paragraph. At the very inception, a question was put to the learned advocate appearing for the appellant as to how could this appeal be maintained in view of the provisions of Section 13 of the Commercial Courts Act 2015, read with Order 43, Rule 1 of the Code. Full stop. Paragraph. Learned advocate appearing for the plaintiff, in answer thereto, seeks to rely on a division bench judgment of this court in the case of Kolkata Metropolitan Development Authority versus DACCON within brackets India Private Limited, reported at 2024 SCC Online Cal 8835. Full stop. He places paragraph 5 thereof to buttress his contention. Colon, paragraph 5 to 4 colon. Colon, full stop here. The same reads thus, colon, here paragraph 5 to 4. Paragraph. A reading of the aforesaid paragraph would reveal that the Honorable Division Bench was satisfied but the opinion was such that it could be appealed against under Section 37 of the Arbitration and Conciliation Act 1996, read with Section 13 of the Commercial Courts Act 2015, and as such, the appeal was entertained. Full stop. Paragraph. In the facts of the case that is now before us, comma, the order impugned is one whereby the plaintiff's application seeking judgment on admission has been rejected. Full stop. Such rejection does not form part of such rejection. Appeal against such rejection has not been provided for either under Section 13 or under Order 43, Rule 1 of the Code. In that view of the matter, we hold that the present appeal is not maintainable. Full stop. The same therefore accordingly stands dismissed. Full stop. Along with the connected application. Full stop. This, however, shall not prevent the appellant from pursuing any other remedy that the appellant may have recourse to, comma, in accordance with law.
After gives a liberty to withdraw. That is possible. Liberty to withdraw, your lordship.
Not of the dictating.
Argue করতে গেলে কেন?
Just see the case law. Much obliged, your lordship.
A.
No, no, no.
Who think this?
I am for the appellant lordship. I am being led by Mr. Bose.
130 crore loan.
No, no, it's
Section 9, my lord.
The loan
Appeal-
was for 130 crore.
130. I don't know, my lord, why they have appealed, because they've got an order of injunction, my lord, against
My lord, we appealed
me.
because at the ad interim stage, my
Injunction is
lord,
passed.
Oh,
limited interim
They have
order.
put an appeal.
Well, I have other prayers in my Section 9 application.
yes.
So limited prayer granted and Section 9 application disposed of.
Yes.
242 crore.
Have you issued section 21?
Yes, Section 11 filed.
What more do you want now at this stage?
Well, Lord, at this
These
stage,
immovable properties, the value of these immovable properties which have been injuncted
yes, my
don't
lord.
cover your claim.
Well, Lord, the difficulty is that now they are trying to deal with the immovable properties.
They can't. They've been
No,
restrained.
no, I'll
And
tell
he
you,
himself
Lordship.
says, my lord, it's worth 250 crores, my lord, paragraph 4.
My Lord, may I just indicate only one thing, my Lord?
And it's a circular, anyway, my lord, that finding is also there.
Apart from the fact that
The
there is a
circular transaction
subsisting
which is
order of
there.
injunction, now this circular transaction, Your Lordship, that this was contended by the respondent in course of hearing in the Section 9 application. That there is this allegedly appears to be a circular transaction. Now, my Lord, the respondent went into CIRP, Corporate Insolvency Resolution Process, in 2018. And this subject loan is a post-CIRP loan. So, my Lord, the circular transaction otherwise at this stage is irrelevant. The fact that there has been a disbursement and the chart. Is the amount is in excess of 150 crores.
Yes.
So, well, based on these submissions, the Honorable Judge has come to a finding. No affidavits, not called for at that stage. So, the Honorable Judge has come to a finding based on submissions made by the respondent in court. I'll tell you, Lordship, my lord, if your Lordship kindly considers at paragraph 7 of the impugned order.
Let us read the order, Mr.
My-
Bose.
my-
Let us
my-
read the
No, the next.
The value the one. About my outstanding.
Assets, illegal assets, and the hypothecated shares
My
all have been,
injunct.
yes.
My lord, apart from my lord, your lordship will kindly see at that stage my application has been injunction, directions for affidavit, consideration of my further praise I would have understood. But at that stage, injunction and my section 9 application has been disposed of. So I have no recourse to seek the other remedies which I prayed in the section 9 application. If your lordship kindly has a,
Yeah, what are those? Tell us.
I'll tell you, if your lordship
And why
kindly,
why should we pass further orders if your
no, my lord,
claim
what
is
I
protected?
yes,
Go before the arbitrator, prove your claim, get an award.
no, my lord, if you-
Interim protection can't give you everything.
no, of course not, my lord. So, my lord, I have prayed for several other orders. So, my lord, at the stage without affidavit, my lord, our respectful submission is that the honorable judge could not have prima facie come to a conclusion at that stage without any affidavit, just based on the ever submissions made by the respondent.
Mr. Banerjee, we were there thinking, without interfering with the order as such, to the extent that the application stands disposed of, we'll resurrect it and send it back with direction for affidavits. File your affidavit.
He is protected.
Correct.
I'm the one, my lord, who should be aggrieved.
He wants to press for other reliefs.
May I, my lord, just point out one thing? My lord, he relies on, my lord, his whatever, my lord, has been hypothecated and mortgaged. Then, my lord, I found out, my lord, that deed is not even stamped.
Take those
Take
points.
this point.
Deed is not even stamp, my lord. He should put in, my lord, that stamp duty first
File your
if he wants to
affidavit.
enforce.
File your affidavit. Take those points.
At least it wasn't
I thought,
taken
my lord,
at the
we
initial
can,
stage.
my lord, come back, my lord, and my lord, I should come up and agree, be, my lord, agree with that, because, my lord, we've already suffered an order, and, my lord, because these are mortgage, my lord, we did not, my lord, take any steps on that basis. But I don't know how, my lord, he's agreed, my lord, and he's got his protection.
No, he is agreed because he thinks he is entitled to more
Further.
protection. Other prayers are there in the application.
Apart from injunction on the secured assets.
My lord, injunction.
And section 11 has been filed.
Hey, देखिए stay petition. Let us see what your prayers are.
My lord, if your lordship kindly takes page 38 of the stay application. My lord, apart from that, my lord, we have one more respectful submission. If your lordship takes the impugned order once and come to paragraph 10 of the impugned order. My lord, this is based on the submissions which has been made by the learned senior counsel for the respondent. If your lordship takes para 10 once, the interim orders prayed for cannot extend beyond what was secured by the respondent. At best, the petitioner can claim protection of what was charged to it. It is prima facie available that the money was lent to Kitply. Kitply refers to a transaction as a fraudulent transaction. The resolution plan of Shrey Multiple Asset Investment Trust Vision Fund was accepted by NCLT Guwahati. This was the resolution plan of Kitply. There was a resolution plan of this Vision India which was approved, and the loan was given to Kitply post the resolution plan, and the object and purpose of the loan was to pay under the plan. The loan document records, and there is a specific clause in the loan agreement which indicates that the purpose of the loan is for payment under the resolution plan. Now, my lord, apropos this, my lord, now consider Vision Fund was accepted by NCLT Guwahati bench, which had approved the resolution plan. Then Trinity is the fund manager of Vision India. My lord, para 10. Trinity is the fund manager of Vision India and control. Trinity is the fund manager of Vision India. Then SIFL had control over ACFL and Trinity. With respect, my lord, how does the learned judge come to this conclusion? Which affects, my lord, multiple other proceedings which are pending. Then the submission of Mr. Court that ACFL took control over Kitply through Vision India has some prima facie basis. What there is no basis. There was no document, there's nothing apart from submission. There's no.
These are not binding.
I'll tell you, Lordship, why.
Observations are prima facie.
I'll tell you, Lordship, I'll tell you, this has an effect on the decision-making process in the Section 9 application. I'll tell you, Lordship, allow me to place some more sentences. The transactions took place after approval of the resolution plan. However, the issues are required to be gone into in greater detail to understand the nature of the transaction, and such determination would be before the arbitrator. For the purpose of grant of interim protection, the court is not required to hold a mini trial. Then, NARCL, as your lordship is aware, is the company which has taken over both ACFL and SIFL. Both the Shrey companies have been taken over by NARCL, which is a consortium of bank, and it's an asset reconstruction company. Has substantial control over, that has wrongly gone down at ACFL, it should be SIFL, and Trinity. Lord, NARCL has no control over Trinity. How did the Honorable Judge come to this conclusion? Then, Trinity is the fund manager of Shrey Vision Fund, which in turn controls Kitply through Platinum. Lord, Platinum is another entity.
But my learned friend, my lord, should be a little fair, my lord, in paragraph 8, in view of the specific finding round tripping by an independent auditor. And as the proceeding before the NCL is still pending. My lord, because he's also filed a section 7. And my lord, we had handed over, my lord, the section 66, my lord, where, my lord, these exact, my lord, findings are there. That's what, my lord, the learned judge relied upon. My lord, if my lord wants me to file an affidavit, I can do that. But I don't think, my lord, because he already, my lord, has made a section 11 application, so he's not served on us. Arbitrator will be appointed. Because absolutely, my lord, case of, my lord, round tripping. He, my lord, gives money, my lord, to this company, pays it back to himself, my lord, and has a resolution plan, my lord, approved.
And my lord, who is complaining of round tripping?
Forget, we are not entering into those things.
My lord, this para
What?
10 and 11 observation, these
Yes.
findings, well,
Yes.
this is not just observation. These are findings of the learned judge. If your lordship will kindly take.
We will make something very clear that
my-
these observations will not affect any future
My
proceeding.
lord,
That's all.
I have, my lord, the section 66, my lord, which, my lord, is
66 is in my CIRP.
Yes.
Is in SIFL CIRP. So 66 is, my lord, needs to be proved. 66 is pending. Just
is one of
because
the
there is a
independent
66
auditor's
and there's a. Well, that auditor's report is not sacrosanct. It is subject to prove.
So, Mr. Bose, if we just clarify that,
My lord.
then we can dispose of the appeal. That's all. We'll clarify that.
Yes, but, my lord, it's at the prima facie stage, quite naturally.
Correct.
Quite naturally. My lord, that, my lord, the order itself says so, my lord, that the arbitrator has to, my lord.
Anyway, issue.
Lord, we can also, my lord, if my lord wants, my lord, we can also file affidavit, my lord, if my lord.
In the trial court?
Yes.
In the trial court.
In the trial.
Then we will resurrect the application, send it back.
Very well.
I could have. Affidavit, put this, all this on record.
Huh?
That's, my lord, that what.
Yes.
We'll file an affidavit, my lord, putting
Yes,
this.
do that.
Well, only one
So
indulgence.
can we say that the suggestion from Mr. Bose is accepted by you?
That it should be resurrected, but I don't want, my lord, the findings, my lord, it's not to do.
No. We are saying nothing more then.
Yes, very well.
We are sending it back.
Very well.
And
Ask the learned trial judge to clarify.
yes, of course. 10 and
single
11.
judge.
10 and 11, and my lord, only if your lordship will see the order has been disposed of. My lord, there's a.
July.
The injunction
Findings,
was
my lord, we can't have them, my lord.
since
This is
it
now,
has
my lord,
been
what is
disposed of.
the appeal after 2 months, 2nd July, my lord, is the order. After, my lord, 2 months has come up because he knows, my lord, there are prima facie findings against him. So the whole idea, my lord, is to ensure that, my
What
lord,
more? We are giving you what you
Para
wanted.
14, my lord, the interim order was for a period of 3 months. So
Yes.
since the application has been disposed of and your lordship is sending it back
August,
for
September,
further
October,
consideration.
2nd, yes, 3 months.
So, my lord. So this will intervene. This is 2nd of July. So this will be on the 2nd of October.
We'll say till the end of October.
My
2nd October within the vacation.
Yes.
So end of October.
End of October.
That's all.
Right.
This appeal is directed against a judgment and order dated July 2, 2025, passed on an application filed by the appellant herein under Section 9 of the Arbitration and Conciliation Act, 1996. Stop. Paragraph. The appellant claims to have lent and advanced huge sums of money to the respondent, in the region of around rupees 243 crore. No?
130.
130.
My lord, my claim today is
Very
243
well. 130 crore. Rupees 130 crore. Stop. The appellant says that presently a sum of about rupees 243 crore is due to it from the respondent. Stop. In view of there being an arbitration clause in the loan agreement between the parties, the appellant approached the learned single judge with the Section 9 application for interim relief. Paragraph. The learned judge secured the claim of the appellant to the extent of injuncting the appellant, respondent from dealing with the mortgage properties and the
Pledge shares.
movables which were hypothecated.
No.
I'm sorry, my lord, once, very well. When my submission, my lord, gets recorded, my lord, saying, my lord, that it is not even stamped because he, my lord, has to put in the stamp, my lord, for
Only-
purpose of hypothecation.
You go back before
Yes,
the,
yes.
Well, limited movables, limited injunction was there only on the pledge shares, not on the other hypothecated asset, because which includes the
Wait, wait.
trademark. That injunction was not granted.
No, no.
Yes,
Yes,
trademark
yes.
injunction was
Yeah.
refused.
and the shares, company shares that were pledged to secure, that were pledged to secure the loan in question. Stop. The learned judge did not grant the other prayers made in the Section 9 application. Stop. The learned judge disposed of the application. Paragraph. Being aggrieved, comma, the petitioner before the learned judge has come up by way of this appeal. Stop. The contention of the appellant is that the appellant should have been permitted to press the other prayers. Stop. The application should not have been disposed of without granting that opportunity to the appellant. Paragraph. Mr. Bose, comma, learned senior counsel appearing for the appellant suggests that the matter be remanded to the learned single judge for being heard out on affidavits, so that the heard out after exchange of affidavits, or after exchange of affidavits, so that the appellant oblique petitioner has an opportunity of praying for further interim orders. Stop. To this course of action, comma, Mr. Banerjee, comma, learned senior counsel appearing for the respondent, does not have any objection. Paragraph. Accordingly, comma, without touching the merits of the case and leaving all points open, comma, we resurrect the Section 9 application and request the learned single judge to decide the same after exchange of affidavits. Stop. The respondent will be at liberty to file its affidavit in opposition
At least a week, my lord, after vacation, my lord.
2 weeks after vacation.
Weeks after.
Within 2 weeks after Puja vacation, date ta diye dao, date ta diye dao. November 7 হচ্ছে বোধহয়।
Yes.
হ্যাঁ? Stop. Reply thereto, comma, if any be filed within
2 weeks thereafter.
2 weeks thereafter, November 21. Paragraph. The parties will be at liberty to mention the matter before the learned single judge for hearing after exchange of affidavits. Stop. The interim order that is in operation shall continue till December 15, 2025, or until further order of the learned single judge. Comma, whichever is earlier. That's it.
My lord, one indulgence, my lord. This findings of the
No.
learned judge in para 10 and 11, my lord,
Yes.
kindly record my submission, my lord. They could not have. My lord, one of my
Paragraph.
grievances.
Rekho,
Lord,
my-
I am-
one of,
my
this
lord,
is one of my
We'll
grievances.
just record, nothing more.
Nothing. This is one of
No,
my
no,
principal
the learned
grievances
judge
where we've
said,
come.
my lord, that these are all prima facie findings. He can't, my lord,
No.
get away, my lord, from the prima
No.
facie findings.
Prima facie finding, my lord, there could
Now
not
we
have
see
been a
that is
prima
all-
facie. Would not have been a prima facie finding without there being any document on
Yes,
record. They
Mr.
could have said that I have
I
filed
don't see your-
affidavit.
Mr. Bose, we will record your submission and put it at that. That is all.
Right,
We are not going to express any opinion on it.
Right.
Mr. Bose, comma, learned senior counsel appearing for the appellant says that, submits that the findings of the learned single judge in paragraphs 10 and 11 of the impugned order could not have been arrived at, as there was no sufficient material in support thereof. Stop. We say nothing on that count and only put the submission on record.
I'm grateful.
Paragraph, the appeal and the application stands disposed of.
তো সেটা তুমি তো পাঠাচ্ছ।
I'm grateful.
I appear for the respondent. Lord.
I appear plaintiff.
On the last
appellant
occasion,
Lord.
Lord, it had fallen from your lordship's Lord, whether a suit which is a non-commercial suit filed in a commercial division can be transferred
Oh.
under section 24.
You considered that judgment?
I have. In fact, Lord, in that judgment, what had happened, Lord, it was a case of section 16 CPC, a suit for land. So it was transferred from the High Court to the District Court. But Millard, the difficulty, Millard, if I may say this, Millard, under section 24, Millard, it can either be withdrawn from or transferred to a subordinate court. That is the specific language and read with section 3 of the CPC, which Millard describes, Millard provides for subordination of court. Millard, this can probably be only be in case where it is transferred. May I just read 24, section 24, Millard? May I please it? That 1A and B, Millard, and section 3, read with section 3.
Possibly right.
Millard, may I also, Millard, hand over the judgment, Lordship was, Millard, 1985 Supreme Court, McNeil and Magor.
On section 24.
Yes, but that was, Millard, in a case, their Lordships, in that judgment has considered 21, paragraph 21 specifically. But that was in a case where it was transferred from the High Court to the District Court. So
High Court to the
District Court. It was originally filed before the High Court. The Honorable Court had considered that it was a suit for land. It could not have been filed in the High Court, and that is why it was transferred.
Correct. Can't be done, sir.
May I say something, my lord? But when a writ petition is filed before a court having jurisdiction, my lord, Article 226 is implied and its powers have been invoked. And it has been found that it is not within the jurisdiction of Article 226, and it is said that the matter may be dismissed and put it before the appropriate authority, appropriate forum or appropriate court. Now, my lord, I have instituted a suit in the High Court having jurisdiction, both ordinary jurisdiction and the commercial division. Only the bench was termed as commercial division. I have instituted a suit. Commercial division, it has been found that it is not, Commercial Courts Act will not be applicable. Commercial Courts Act goes out of the picture. What will be there? CPC. Does the court does not have the power of CPC? It can only change the nomenclature. Only change the nomenclature, because there is no harm to the defendants. If the case goes from commercial division to the non-commercial division, there is no rights of the defendant that is curtailed. The courts does have the power of ordinary original jurisdiction, my lord. This is an appropriate court. Court is appropriate, my lord. Only the division, only the bench is different, in my perspective, my lord. And moreover, my lord, the division bench judgment that I have relied on, there also, my lord, I do not disagree with it. I am only saying that in the impugned judgment, what the learned single bench has done, they have simply returned the plaint and have not given the directions that has been laid down in the division bench. The directions that has been laid down in the division bench is renumbered the suit, and the interim order will also continue. But that has not been done. That was my only grievance from the impugned judgment.
Order 7, Rule 10 is not applicable.
Milord, the
Chartered High Court.
Order 49, Rule 3, but it was amended in 1976.
Yeah,
I'm omitting that application to high courts. So now, Milord,
it
perhaps
should be
there are
applicable.
conflicting judgments I have found, but it should be applicable to the high court as well. 1976 or 77, there was an amendment.
This judgment doesn't take note of that amendment.
Yes, it does not. Lord, in paragraph 20, I believe, Milord, it does not take note of that. But there are judgments, Milord, which has taken note of that. When Justice Arindam Mukherjee's judgments I have found, Milord,
Bring those judgments.
Yeah,
very well, Milord.
and the relevant notification.
That, Milord, I have found, Milord, searched a lot since
Anyway,
fact,
bring the relevant.
but I'll try because
Friday,
it is
Friday.
there. It is there in Sarkar on CPC and all that. It is there. That notification is there.
Come on,
So I'll try and bring that. book.
come on Friday.
But
Come.
only thing about this judgment that has been relied on, if the plaintiff is returned to me and being renumbered, I have no other grievance and no rights of the defendant is being cut.
Under Order 7, Rule 10, that is the procedure. It had to be presented. It will be
I will
renumbered.
present it before the non-commercial division. Only
it
the
with the
interim
High
order
Court.
will be extended.
To enable learned counsel for the parties to rely on authorities in support of their respective contentions, let this matter stand adjourned and be listed again on Friday date, under the same heading.
Deep level.
Objection now.
But I'm being led by Mr. Jishnu Shah, Milord. He's not there today. I was praying for a non today, Milord.
Milord, I am pressing for an
Milord,
order.
I am for
There
the
are a
plaintiff
series
respondent.
of counsels, Mr. S.N. Mukherjee.
No,
Milord,
for the
my
plaintiff, Milord.
NCLT proceedings have been completely rendered nugatory by reason of a civil suit which has been filed subsequently. Now, Milord,
Kindly takes it up tomorrow, Milord. The order impugned is of 19th August, Milord. I'm praying for 1 day.
Milord, the matter appeared before NCLT. I am being
On the ground of Mr. Shah, they are seeking a day's time.
Milord, you can, but there are other Mr. S.N. Mukherjee is here.
Milord, he was
Mr.
Trial court for one of the parties.
Milord, defendant, Milord. No.
Then
Milord, Mr. Mukherjee is for one of the defendants, Milord.
Mr.
Plaintiff,
Shah's junior is also there.
Mr.
Mr. Shah's junior, okay, chilo. Na, arekta. Na, arekta. Well, I leave it to your lordship, but my NCLT proceedings, which is a prior proceeding,
Milord, listed on 16th October, Milord. So it's not
because it
today or
was
tomorrow.
taken up for hearing in August, and Milord, in August, the order was passed.
Mr. Bose,
Yes.
the order was passed on the 19th of August.
Yes, I have.
If the heavens were falling, your client wouldn't wait till the 1st of September
Yes,
to file the appeal.
yes, Milord, I did.
Not today.
Deeply, please.
Not today.
Milord, I told you I'll leave it, but not to press. Please take it up. I mean tomorrow.
Yes, only not today. We have said only not today.
Oh, appellate side. आप की बोल He's saying I've been debriefed.
Sorry, Baba.
डाटा तो डाके नहीं है डाटा तो डाके नहीं Millard, I had Millard cited Millard the three decisions Millard of Millard two of Calcutta High Court and one Millard Supreme Court Millard on the last occasion and Millard this was vis-a-vis Millard the Copyright Act as it stood Millard even before the 1995 amendments. Millard, kindly Millard just take that Supreme Court once Millard once again Millard. That's 1977, two Supreme Court cases 820. And I'd handed it up. No, mark kora আছে।
Yes.
My lord, kindly come to my lord para 15. My lord, just two paras I want to my lord read my lord to give the two different scenarios. My lord, kindly come to my lord para 15 at page 830. My lord, kindly take my lord the last 10 lines starting with section 13.4.
Yes.
Right hand side. Section 13, my lord, why am I citing this, my lord, is this is where, my lord, there is already a copyright. My lord, the musical work and the lyrical work, my lord, the lyrics, my lord, are in existence. So there's a copyright in the musical work, copyright in the literary work. Then, my lord, kindly see what happens. Section 13.4, on which Mr. Ashok Sen has leaned heavily in support of his contentions, lays down that the copyright in a cinematograph film or a record shall not affect the separate copyright in any work in respect of which or a substantial part of which the film or as the case may be the record is made. Though a conflict may at first sight seem to exist between 13.4 and 14.183 on the one hand and 14.1c2 on the other, a close scrutiny and harmonious and rational instead of a mechanical construction of the said provisions cannot but lead to the irresistible conclusion that once the author of a lyric or a musical work parts with a portion of his copyright, because my lord, one of the bundle of rights is to make a film. By authorizing a film producer to make a cinematograph film in respect of his work and thereby to have his work incorporated or recorded in the soundtrack of a cinematograph film, the latter acquires by virtue of section 14.1c of the Act on completion of the cinematograph film a copyright which gives him the exclusive right inter alia of performing the work in public, that is to cause the film insofar as it consists of visual images to be seen in public and so far as it consists of the acoustic portion including a lyric or musical work to be heard in public without securing any further permission of the author composer of the lyric or musical work for the performance of the work in public. And then my lord talks about a distinct copyright. Now my lord, kindly come to paragraph 17. My lord, page 832. This is my lord an engagement before the existence, my lord, of the musical work or the literary work. Kindly see what's happening here. This takes us to the core of the question, namely whether the producer of a cinematograph film can defeat the right of the composer of music or lyricist by engaging him. The key to the solution of the question lies in provisos B and C to section 17 of the Act reproduced above, which put the matter beyond doubt. According to the first of these provisos, namely proviso B, when a cinematograph film producer commissions a composer of music or a lyricist for reward or valuable consideration for the purpose of making his cinematograph film or composing music or lyric, therefore, the sounds for incorporation or absorption in the soundtrack associated with the film, which has already indicated are included in a cinematograph film, he becomes the first owner of the copyright therein. That means, my lord, here the producer, my lord, is not only, my lord, the first owner of, my lord, the film. My lord, he is also, my lord, the owner of the copyright. My lord, in, my lord, the musical work as well as the literary work. First owner of the copyright therein, and no copyright subsists in the composer of the lyric or music so composed, unless there is a contract to the contrary between the composer of the lyric or music on the one hand and the producer of the cinematograph film on the other. The same result follows according to aforesaid proviso C if the composer of music or lyric is employed under a contract of service or apprenticeship to composer. It is therefore crystal clear that the rights of a music composer or lyricist can be defeated by the producer of a cinematograph film in manner provided in provisos B and C. Then, my lord, I placed, my lord, Justice Krishna Iyer's judgment, my lord, which is to be read as a footnote, and my lord, as my lord, the learned judge himself wanted, and my lord indicated that, my lord, what he was voicing, my lord, was, my lord, right should be created, my lord, in favor of, my lord, the performers, my lord, as far as, my lord, Indian, my lord, music is concerned. It was only performers' rights, my lord, which were, my lord, articulated there. Now, my lord, kindly take, my lord, the Copyright Act, my lord, in its present form. Amendment, আগের amendment গুলো লেখা আছে দেখো। No, just forget it. What is this? Yes. No, forget it. Yeah, my lord, we've got acts. Oh. My lord, I don't know if the footnotes, my lord, have, my lord, because, my lord, the
Which section are you showing?
my lord, first, my lord, will be, my lord, section 37 onwards, my lord, chapter 8, organization of performers.
The 21 amendments are not there, but 2012 amendments are there.
21 amendments.
My lord, I don't know if your lordships, my lord, have, my lord.
देखिए दाও। এটা আছে, এগুলো 2012 amendment. 2012 amendment we have in our.
No, my lord, this is, my lord, I'm showing, my lord, 95 amendment. This is 2012.
Yes.
My lord, but, my lord, I'm showing first, my lord, performers' rights, my lord, apropos, my lord, the observation of, my lord, Justice Krishna Iyer, my lord, certain amendments were introduced, my lord, in 1995.
Correct. Yes, we have that.
Lordships have that, my lord?
Yes.
My lord, kindly see, my lord, section 37. My lord, this was, my lord, broadcast reproduction right, my lord, which, my lord, and 190, my lord, where footnote 190, my lord, is the
Yes.
my lord, that was, my lord, the additional amendment in 2012. I'm not troubling your lordship with that. My lord, kindly come to section 38. My lord, which is, my lord, performers' rights. Your lordships have that, my lord?
38.
Yes.
Yes.
Now, my lord, this was, my lord, a 1995 amendment where any performer appears or engages in any performance, he shall have a special right to be known as the performer's right in relation to such performance. Lordships have that, my lord?
Yes.
The performer's right shall subsist until 50 years from the beginning of the calendar year next, following the year in which the performance is made. Then, my lord, subsection 3 was also there, which, my lord, the 2012 amendment, my lord, does away with. Kindly have a look at subsection 3. During the continuance of a performer's right in relation to any performance, any person who, without the consent of the performer, does any of the following acts in respect of the performance or any substantial part thereof, namely, makes a sound recording or visual recording of the performance, or B, reproduces a sound recording or visual recording of the performance, which sound recording or visual recording was made without the performer's consent or made for purposes different from those for which the performer gave his consent, or 3, made for purposes different from those referred to in section 39, from a sound recording or visual recording which was made in accordance with section 39, or C, broadcast the performance except where the broadcast is made from a sound recording or visual recording other than one made in accordance with section 39, or is a rebroadcast by the same broadcasting organization of an earlier broadcast which did not infringe the performer's rights, or D, communicates the performance to the public otherwise than by broadcast, except where such communication to the public is made from a sound recording or a visual recording or a broadcast, shall, subject to the provisions of section 39, be deemed to have infringed the performer's right. So, my lord, performance also, my lord, had, my lord, similar rights, my lord, to, my lord, an author, or, my lord, the first owner of the copyright. Now, my lord, kindly have a look at 4. Once a performer has consented to the incorporation of his performance in a cinematograph film, the provisions of subsections 1, 2, and 3 shall have no application to such performance. My lord, this was, my lord, the recognition, my lord, which was, my lord, given to, my lord, performers. Then, my lord, we have, my lord, the 2012, my lord, amendment. But, my lord, before, my lord, I go to that, my lord, 3 other cases, my lord, I need to show. My lord, even after, my lord, this incorporation, my lord, of, my lord, performers' rights, my lord, the Copyright Act, my lord, came up for consideration. My lord, by, my lord, the Supreme Court. My lord, the first decision, my lord, in this regard, my lord, is 2008, 13 SCC, page 30. My lord, I am citing this, my lord, for the proposition, my lord, that, my lord, the Supreme Court recognizes, my lord, the copyright in a sound recording, my lord, to be in no manner less than a copyright, my lord, in a musical work or a literary work. My lord, kindly come to, my lord, paragraph, my lord, 26, my lord, at, my lord, page, my lord, 49. My lord, these were, my lord, the issues which, my lord, arose, my lord, in this matter. Lordships have that, my lord. Print page 20, I believe.
Yes.
My lord, page 49 of the report. My lord, the core questions which therefore arise for consideration in these appeals are whether the Copyright Board has jurisdiction under section 31(1)(b) of the Copyright Act 1957 to direct the owner of a copyright in any Indian work or a registered copyright society to issue compulsory licenses to broadcast such works where such work is available to the public through radio broadcast. Where in any event such a compulsory license can be issued to more than one complainant in the light of section 31(2), and what would be the relevant considerations which the Copyright Board must keep in view while deciding on whether to issue a compulsory license to a particular person, and B, the terms on which the compulsory license may be issued, including the compensation. Now, my lord, I pause here. My lord, copyright, my lord, the rights, my lord, intellectual property rights, my lord, are statutory rights. My lord, the policy, my lord, is, my lord, of law is, my lord, to frown on monopolies. But, my lord, the policy, my lord, is also to encourage creativity. So, my lord, a question arose, my lord, there are, my lord, provisions for compulsory licensing, because certain works, my lord, need to be made available to the public. So, my lord, it was on this issue, my lord, that this case, my lord, was being decided. Now, my lord, kindly come to, my lord, paragraph 41 at page 51 of the report, which is, my lord, print page 22. The lordships have that, man. Sections 18 and 19 relate to assignment of copyright and mode of assignment respectively. Section 19 deals with disputes with respect to assignment of copyright. Section 27 provides for the term of copyright in sound recording in the following terms. Then section 27. Term of copyright in sound recording. In the case of a sound recording, copyright shall subsist until 60 years from the beginning of the calendar year next, following the year in which the sound recording is published. However, only because the term for holding copyright under the said provisions are different, the same would not mean that the right of the copyright owner in sound recording is somewhat inferior. Then, my lord, kindly come to, my lord, paragraph 87. My lord, '87 at page 85, my lord. Sorry, not 87. I'm sorry, my lord. My lord, page 66, my lord. Kindly come to page 66, my lord. Yes, correct. My lord, yes. Yes, my lord, page 65 to page 66, my lord, paragraphs 87 to 93. Kindly have a look. My lord, after discussing, my lord, the law in all the other countries, which, my lord, the Supreme Court thought fit, my lord, it comes to, my lord, our Copyright Act. My lord, kindly see, my lord, the, my lord, essential features of the Copyright Act. The Act seeks to maintain a balance between the interest of the owner of the copyright in protecting his works on the one hand and the interest of the public to have access to the works on the other. The extent to which the owner is entitled to protection in regard to his work for which he has obtained copyright and the interest of the public is a matter which would depend upon the statutory provisions. Whereas the Act provides for exclusive rights in favor of owners of the copyright, there are provisions where it has been recognized that the public has also substantial interest in the availability of the works. The provisions relating to grant of compulsory license must be viewed having regard to the aforementioned competing rights, wherefore an appropriate balance has to be struck. For the said purpose, we may notice the broad features of the Act. Then, my lord, is, my lord, section 89, my lord, is, my lord, copyright. Then, my lord, 90, my lord, voluntary licenses. The freedom to contract is the foundation of economic activity and an essential aspect of several constitutional rights, including the freedom to carry on trade or business carried under so and so. But the said right is not absolute, it is subject to reasonable restrictions. Then, my lord, Section 30 enables the owner of the copyright to grant any interest in the copyright by a license in writing, signed by him or by his duly authorized agent. The underlying philosophy of the Copyright Act is the owner of the copyright is free to enter into voluntary agreement or licenses on terms mutually acceptable to him and the licensee. The Act confers on the copyright owner the exclusive right to do the various acts enumerated in Section 14. An infringement of copyright occurs if one of those acts is done without the owner's license. A license passes no interest but merely makes lawful that which would otherwise be unlawful. Then, Millard, the Act also expressly recognizes the notion of an exclusive license which is defined in so and so. But that does not mean, as would be noticed from the discussions made here and after, that it would apply in all situations, irrespective of the nature of the right, as also the rights of the others. It means a license which confers on the licensee, to the exclusion of all other persons, including the owner of the copyright, any right comprised in the copyright in a word. An exclusive licensee has specific rights under the Act, such as the right to have recourse to civil remedies, and this scheme shows that copyright owner has complete freedom to enjoy so and so. And Millard, then it goes on to say that Millard, they have full freedom to enjoy fruits of his work by earning an agreed fee or royalty through issue, but this right to repeat is not absolute. It is subject to right of others to obtain compulsory license, as also the terms on which such license can be granted. And Millard, compulsory licensing, Lordships will find Millard, is Millard provided Millard in Millard the Act itself. So Millard, this is Millard recognized as the essential features Millard of Millard the Copyright Act. Then Millard comes the 2012 Act. Now I must Millard place and Millard, before Millard it Millard comes into effect, two judgments Millard I wish to show. Millard, apropos Millard, sound recording. Millard, this is first Millard, the judgment Millard of the learned single judge. And Millard, the reason I cite it is Millard, to the extent it recognizes sound recording to be an independent copyright. Millard, there has been no change in law. And Millard, similarly, Millard, I cited the Supreme Court Entertainment Networks case, that it's no less a copyright, Millard, than Millard, the other Millard, copyrights which can subsist, Millard, in works like Millard musical and Millard literary work. Now, Millard, kindly take the learned single judge's judgment in IPRS versus Aditya Pandey. Millard, this is reported in 2011, SCC Online, Delhi 3113. My lord, kindly see paragraph 1. The plaintiff, hereafter IPRS, seeks permanent injunction and other consequential reliefs against the defendant, alleging that the latter is guilty of copyright infringement. IPRS has an IA so and so claim temporary injunction. Now kindly come to paragraph Millard 34, Millard. Millard, the heading is analysis and reasoning. Para 34, which is print page 11. Millard, kindly see Millard, the Millard arguments, Millard and Millard. From the above discussion,
Para 34.
Millard, para 34, print page 11. Millard.
11, 16.
What copy have you given there?
Print page 16.
Para 34, your lordships have.
Print page 16 in our copy.
Lord, this is from the web edition, that's why.
Yes, analysis and reasoning.
Yes. From the above discussion, it is evident that two questions arise for consideration in this case. First, the extent of the songwriter's copyright and whether it extends to excluding the communication to the public without authorization of the musical work embodied in a sound recording. And two, does hiring of a place hired by an employer and its use by the event manager for the purpose of communication of musical works or sound recordings amount to public performance within the meaning of the Act? The first question framed by this court arises in both the suits, but was primarily argued in IPRS's suit against Synergy. IPRS contends that Section 13(1) clearly stipulates that copyright subsists in inter alia original music and artistic works, and also in sound recordings. It roots his claim essentially on a joint reading of Section 13(4) and Section 14(a)(3). The submission is that if a songwriter allows his work to be embodied in a sound recording, secondary copyright, kindly mark the words, my lord, secondary copyright forming the sound recording no doubt encompasses the copyright owner's right to communicate the sound recording to the public by virtue of Section 14(e). IPRS submits that this, however, does not detract from the separate and independent right of the songwriter whose copyright in the work and the concomitant right to authorize its communication to the public subsists, unless it is proved that such right has also been parted to the owner of the sound recording. IPRS contends that in either case, the merger of ownership does not have the effect of merging the two copyrights. Reliance is also placed on the definition of communication to the public under Section 2FF, which includes the making of any work available for being seen or heard by the public directly or by means of display or diffusion, other than by issuing copies of such work, regardless of whether any member of the public actually sees, hears, or otherwise enjoys the work thus made available. It is submitted that the oral perception of one song played through means of a sound recording encompasses authorized renewal, does not in any manner deflect from the separate copyrights which subsist and should exist by virtue of Section 13(4). My lord, this was, my lord, the argument. Now, my lord, kindly come to my lord, para 43. Print page. Page 27. I believe it's print page 27, man. Lordships have that, my lord. The plaintiffs in both the suits urge that with the amendment of 1994, the situation has changed and the sound recording owner has become the copyright proprietor of a soundtrack created by him or under his authority. This no doubt confers the right to do or authorize the doing of various things by virtue of Section 14. However, his authorization to anyone, including a broadcaster, to communicate the sound recording or broadcast it to the public, does not detract from the separate copyright vesting in the author of the musical work by virtue of Section 14(a), which operates independently, enjoining the person seeking to broadcast the lyrics to secure the permission of the composer or the lyricist. The plaintiffs urge that the definition of communication to the public and the structure of the separate rights inhering in every owner by virtue of Section 13(4) strengthens this operation. They have relied on several rulings of the courts in UK and Australia to say that public performance rights, kindly mark this, my lord, public performance rights of lyricists operate independently of sound recording right to authorize broadcast. At this stage, it would be necessary to consider legal provisions existing in the UK and USA, relevant provisions, my lord. They are my lord, set out. Then, my lord, kindly come to my lord, an analysis of this. My lord, kindly come to paragraph 46. Print page 31, my lord. So far as the UK enactment goes, the wordings of section 16, 19 and 20 of the Copyright Designs and Patents Act amply clarify that each infringement and even the method of communicating the work to the public is defined specifically in relation to the nature of the copyright. In view of these observations, this court is of the opinion that the decision cited on the question of copyrights and the amplitude of the various rights cannot be blindly replicated or followed, having regard to the difference in structure in the Indian enactment and the judgment of the Eastern Motion Pictures Association, the case I cited, of the Supreme Court. It would be relevant at this stage to deal with the plaintiff's argument that fixation or tangibility of a work does not determine the existence of the right. This contention was made in the context of whether the existence of a sound recording copyright in relation to a work per se subsumes the copyright of the author or owner of a music or literary work. In this context, the judgment in Sawkins may be usefully noticed. The court observed inter alia that in the absence of a special statutory definition of music, ordinary usage assists. As indicated in the dictionaries, the essence of music is combining sounds for listening to. Music is not the same as mere noise. The sound of music is intended to produce effects of some kind on the listener's emotions and intellect. The sounds may be produced by an organized performance on instruments played from a musical score, though that is not essential for the existence of the music or of copyright in it. Music must be distinguished from the fact and form of its fixation as a record of a musical composition. The score is the traditional and convenient form of fixation of the music and conforms to the requirement that a copyright work must be recorded in some material form. But the fixation in the written score or on a record is not in itself the music in which copyright subsists. There is no reason why, for example, a recording of a person's spontaneous singing, whistling or humming, or of improvisations of sounds by a group of people with or without musical instruments should not be regarded as music for copyright purposes. The fact that in musical copyright the sounds are more important than the notes in the text is recognized, for example, in the approach to infringement. The test of substantial reproduction is not a note-by-note textual comparison. It involves listening to and comparing the sounds of copyright and of infringement. So it is possible to infringe the copyright in a musical work without taking the actual notes. Then, my lord, this is, my lord, very much in line with, my lord, what, my lord, Justice Krishna Iyer, my lord, had, my lord, said in the footnote, which had resulted, my lord, in, my lord, the amendments. Now, my lord, para 48. There is no difficulty in appreciating the plaintiff's contention that the existence of copyright in a word does not preclude the existence of another copyright in relation to it if it comprehends a multitude of original copyrightable works. The ruling in Stephen Cowardin and Company informs this. So does the intent and structure of Section 41 of the Copyright Act. Thus, when a lyricist or musical composer creates an original musical work, the lyrics and the score, he becomes entitled to exercise all the rights enumerated in Section 14A. That is, to reproduce the work in any material form, issue copies of the work to the public, to perform the work in public, or communicate it to the public, to make any cinematograph, film, or sound recording in respect, to make any translation, to make any adaptation, and to in relation to a translation or an adapt to any of the acts specified. However, the court has to take into consideration the interpretation given to the statute by the Supreme Court. That was no doubt during a time when sound recording copyrights did not independently exist and were perceived as part of the copyright in a film. The court had then ruled in the Eastern MPA judgment, if the film owner or copyright proprietor wishes to exhibit the film, including the song, he is not required to seek authorization or separate license from the music composer or lyricist for communicating the work to the public, since this is an integral part of the film. That was in the interpretation given to Section 14C of the Act. Parliament amended the Act in 1994. A new copyright in sound recording was introduced. The content of this right, unlike the US law or the UK law, the latter being specific, extends to making any other sound recording embodying it, to sell or give on hire or offer for sale or hire any copy of the sound recording, regardless of such copy has been sold, etc. In a sense, a textual reading of the two rights, sections 14A and 14E, would suggest that the plaintiff's arguments have substance and merit. This can even be seen to be reinforced by the seeming preservation of separate copyrights under section 13.4. Yet, the court cannot be oblivious of the binding Eastern Motion Pictures Association and the anomalous consequences would follow if the plaintiff's arguments are accepted. The Eastern Motion Picture ruling is categorical. Then, my lord, the portion I read out, my lord, is, my lord, quoted. If one notes that sound recording copyrights post 1994 have been carved out of the pre-existing copyright in respect of films, and acceptance of the plaintiff's argument would lead to two kinds of copyright. In such case, for instance, the copyright proprietor of a film who happens to own the sound recording can authorize the broadcast or communication to the public of the film, including the sound recording part, as a composite part without license from the author of the lyrics. However, if the copyright owner of a sound recording is different from the owner of the copyright in the film, assuming the plaintiffs are correct in this, a separate authorization from the lyricist or composer would be necessary. This is despite the fact that a sound recording is work under the Act and is capable of an independent copyright under 13.1. This anomaly is further aggravated if one sees that sound recording of a film, the communication of which is authorized by the film copyright owner, would not require separate authorization from the author of the film or literary work, whereas in the case of an owner of the copyright in sound recording, an identical authorization by sound recording copyright would be insufficient, and possibly two more authorizations or licenses from the lyricist and other composer would be required. Thus, the unity of ownership of film owner in respect of the film and sound recording embedded in the film works to the advantage of the licensee, who, once having obtained authorized from owner or does not have to revert to the copyright owner of the. In the case of sound recording copyright owner, when the whole of the sound recording work is licensed to be communicated to the public, yet the licensee, unlike the licensee of a film, who too can communicate the whole of the work and not merely the musical word, would be compelled to approach the author of the literature. Thus, the interpretation suggested by IPRS would lead to discrimination in regard to identical content of copyrights of two different works, which undermines the purposes of the Act and is also illogical. This aspect has been highlighted not just to disclose the anomaly, but the fallacy in the plaintiff's argument, which would result in two kinds of copyrights differing in content and character, where the statute plainly decrees the fullest extent of what is permitted. The Act unambiguously points to the film copyright content, including the authorization to communicate the work to the public, which, according to Eastern MPA judgment, extends to permitting the communication of sound recording parts along with cinematograph film without separate license from the author of the musical work. It is also unambiguously points to an identical right to the copyright owner of a sound recording to authorize the communication of the work to the public. Two different approaches to identically phrased rights, one carved out of a pre-existing right, would render the quality of the license obtained from sound recording copyright owner inferior. The reasoning in Eastern MPA is not only reinforced but extended by the creation of sound recording copyright post 1994. The court therefore deems it appropriate to adopt an appropriate interpretation consistent with the one indicated in Eastern IMPA judgment. Without getting into niceties, etc., then Millard, after that, Millard kindly comes straight away, Millard, to the last, Millard, 15 lines of para 49. Millard, kindly see, Millard, the sentence starting having regard. Millard, right hand side it starts. Having regard to these aspects, the plaintiff's contentions about the authorization of a sound recording copyright owner being insufficient and the authorization of the copyright owner of a broadcast cannot be accepted. It is therefore held that once a license is obtained from the owner or someone authorized to give it in respect of a sound recording for communicating it to the public, including by broadcast, a separate authorization or license is not necessary from the copyright owner or author of the musical and or literary work. However, this would not mean that the musical or literary work can be otherwise performed in the public as opposed to communication of a sound recording without authorization. In such event, the author's owner's license or authorization is necessary. In other words, it is clarified that the other bundle of rights which authors or owners of musical or literary works are entitled to enforce remain undisturbed.
We'll come back.
Yes. My lord, there's at direction, my lord, we've served the other side. My lord, we have to file, my lord, accounts.
Oh, I see.
My lord, those affidavits, my lord, already. For this month, my lord. For August. Lord,
এই
maybe recorded, my lord, that we.
ওই যখন অর্ডার রেকর্ড করা হবে এটাকে রেকর্ড করে মনে করিয়ে দিও।
My lord, I was on para 49.
Yes.
Now, my lord, kindly take, my lord. I thought your lordships might rise early. That's why I went to, my lord, having regard. But I just wanted, now that we have time, my lord, I want to show, my lord, the first part also, because this will be very important. Apropos, my lord, the main matter. My lord, it was there in the division bench, but my lord, I want to show this also. Without getting into niceties about the fixation of copyright in a material and object, and whether each copyright in the work exists in a, kindly mark this, disembodied manner, as is urged by the plaintiffs who rely on section 13.4, there is another aspect which cannot be ignored. When a sound recording is communicated to the public by whatever means, it is the whole work. That is the lyrics, the score, the collocation of sounds caused by the equipment, and the capturing of the entire oral experience. The musical or literary work per se, which is the subject matter of copyright under section 14A, is not communicated or broadcast, nor is there a method of separating that element while communicating the entire work, that is the sound recording, to the public, without in any manner detracting the originality or undermining the effort of the lyricist or musical composer. There can be no gainsaying that the parliamentary recognition by the 1994 amendment that sound recordings are capable of original and creative effort, uniquely blending sound, modern technical skill, score, and lyrics, means that the content of a sound recording is perceived in law as different from that of a musical or literary work, though there may be a coalescence of the two, but not necessarily so all the time. Therefore, it would be unjustified to say that when a sound recording is communicated to the public or played in the public or broadcast, the musical and literary work is also communicated to the public through the sound recording. That would be to attribute to the one wishing to communicate that work to the public, that is the sound recording, an intention to do something else, that is communicate the musical or literary work to the public, which is not correct. Yet again, a given musical or literary work may in itself not be popular, and instances of these last years reveal that the sound recording containing other elements, including the performer's efforts, may be critical in popularizing them or rendering them commercially viable. The transformative nature of a sound recording, which uses a musical and literary work, authorized, of course, to be embodied in the sound recording as an element, therefore has to be recognized. Then, my lord, I've read the, my lord. Now, kindly come to, my lord, the order, therefore. My lord, there were two suits. My lord, one was, my lord, an event manager suit, which you are not concerned with. My lord, the IPRS suit, my lord, kindly come to para, my lord, 55. Print page, tell me. Print page 40, my lord. In the light of the above conclusions, which are prima facie in nature and do not preclude the plaintiffs in both cases from establishing and proving their case, the following directions are issued. In the synergy suit, the applications for temporary injunction so and so are disposed of that by stating that the defendants do not have to secure a license from the plaintiffs. That was, my lord, IPRS. Now, my lord, the matter went to the division bench. Now, my lord, this is reported in 2012 SCC Online, Delhi 2645. My lord, kindly take, my lord, paragraph 1. What we commonly understand as a song consists of 3 elements: lyrics, music, and singing. There are 3 players: the lyricist who provides the words, the musician who provides the music score, and the singer who provides the sounds to the words. The trinity join, a song is created. Thus, a song is music which is vocal in character. It is but natural that in a song, the words and the music have a special relationship. Words affect the melodic line, even the rhythmic structure. The inflection of the language in the lyrics leaves an imprint on the melody and the rhythm, on style and phrasing. When a song is sung, there is a moving romance between the words and the music. Not necessarily so, melody, it can be different. Well, do the identities break when their fusion creates a synthesized product? That is when a song is recorded. Undoubtedly, when a song is recorded, there is homogenization of the lyrics with the musical score, where integration is articulated through the multi-level hierarchical system of interdependence. But integration is not fusion, just as differentiation is not fission. Can it be said that the development process, creation of a song, is based neither on integration without differentiation nor on differentiation without integration? Can it be said that the process of creating a song unfolds itself through the simultaneous integration of the differentiated and the differentiation of the integrated? None could doubt that the discernible coloration of words, literature, and music gives a song a consciousness of its own, and thus a song may exist as an independent entity, but not separated from the consciousness of the words and the music. A song which is recorded is the result of the merger of the creative talent of the 3 so and so. When played, it is dichotic. It simultaneously stimulates the ear, the lyric, and the music. It has to be, because the singer and the musician play simultaneously upon the words and thus create a dichotic effect. Integration is a difficult concept, etc. Then, Millard, kindly come to Millard. Sri Aurobindo is also quoted, and kindly come to para 16. Millard,
Where's Sri Aurobindo quoted?
Millard, this
13.
is Millard para 13, I think.
Right.
Then, Millard, kindly come to para 16.
Did this learned judge reach Supreme Court? No.
No, the learned single judge did.
Yes, that we know.
Yes, but Millard, not Millard. Millard, there's an acknowledgement here. There, Millard. What created a problem, Millard, was Millard, there was no acknowledgement. Millard, I have had occasion, Millard, to appear Millard, before Millard, both learned judges, Millard, when they were in Delhi High Court. The learned single judge, Millard, was pleasanter, if I may.
Yes. Yes.
Millard, kindly come to paragraph 16. The fabric in which the constitutive elements are deeply interwoven is the Copyright Amendment Act as amended so and so. And as we evident from our discussion, the data, that is the sections which we are called upon to analyze, reveal a reality of the whole being multinational. And before we proceed to analyze the same, not as reductionists, but by seizing the dynamic pattern which constitute all substances and applying the corresponding measure and rhythm, by ensuring that dynamism inherent in the reality is not isolated, we list the fabric. Millard, come straight away. Millard, to Millard, paragraph 30. Millard, which is print page 16, Millard.
16.
Millard, Copyright Act, as it originally stood enacted, recognized 3 classes of work: Millard, literary, dramatic, musical or artistic, cinematograph, film, and record. Whereas musical and literary works are original works, records is a derivative work. Recording was defined in so and so to mean the aggregate of sounds, etc. Then Millard 31, Millard, the amendment, Millard, was to strengthen copyright law. Then, my lord, 32, my lord, where sound recording comes in, my lord. I'll show that also. 32, my lord, deals with, my lord, section 14, my lord, which, my lord, is the ownership of copyright. Then, my lord, entertainment network, my lord, I have already cited, my lord, paragraph 33. My lord, paragraph 34, kindly see, my lord, from the above observations of the Supreme Court and the wordings of sections 13 and 14 of the Copyright Act 1956, it emerges that the rights of an owner of a sound recording are in no way inferior to those of an owner of copyright in the original literary or music. This was a proposition which was not challenged by either learned counsel. The area of dispute is what happens to the copyright in an underlying work, literary and musical works, when the derivative work, sound recording, is exploited. Does he who obtains permission from the copyright owner of the derivative work to broadcast by way of communicating to the public said derivative work additionally requires a similar permission from the owner of the underlying works, that is the literary and musical works? The three classes of work referred to in so and so are mutually exclusive. As already noted here and above, section
Mr.
13.
Mukherjee, can we release Mr. Mitro, Joyanto Mitro?
Yes, of course.
If this continues till recess, I see. Yes, yes, that is correct.
He was here, my lord, I don't know.
He's, yes. So, yes, then this will continue.
Yes.
So at least till recess. After recess, yes. After recess, you want to do it?
After this, today I think there's a
There is. If you want to do it, we'll have to take it up. Otherwise, we'll join that.
the farewell, my lord, I think it's from 1 to 3.
1, 2, 3, correct.
At least there's a bar station and my lord, the ILS.
Yes, we are aware.
Seeing my lord that do not want to. Because Mr. Sin also came and my lord informed me about that. So
Yes.
I was not followed.
If we all go, then we can go. Otherwise, we can't.
Friday, today, my lord, perhaps my lord.
I thought that my learning was very much interested
to
have the matter.
I am today, but my lord, phone has taken precedence, my lord, over.
Yes. Nothing
You tell us. You tell us.
No, phone, Iman. Well, I am quite ready, to do it, but today I don't know. Today, perhaps there will be some.
Let us continue with this till recess. And
because, my lord, some photographs have circulated. My lord, my learned friends in some, my lord, Mr. Mitros in some, my lord. Of, no, no, উনি বসে আছেন তোমার নোট নিচ্ছে সব আছে। My lord,
last occasion.
showing, my lord, that in spite of resolutions, there is a set of lawyers who keep appearing.
oh, I see. We are not aware.
No. Mr. Mukherjee's photograph, I don't know why they missed Mr. Mukherjee.
Entirely up to
No, that's
no, Mr. Mukherjee, we'll do this. After recess, we'll come and sit. If you are here, we'll hear. Otherwise, we'll call the list and rise.
Farewell, my lord.
You just inform me whether you are coming. If you come, then I come.
Farewell,
No, I am not on that. You
His farewell is there. So that's why I said, if you are not here, we'll call the list and.
That's right. If you are not here, then I won't be here. As simple as that. Only to utter ছিল
না আমি এখনো করতে চাইছি স্যার
করো না
আমি তো এখনই করতে চাইছি
পুরো করবো।
so that I know exactly whether I have to come or not to come. The decision is yours, Mr. Babu.
No, the decision is not mine.
No,
There is a
decision is
today,
yours.
I think
I am waiting for your decision.
embarrassment. I want to do the matter, but
এই একটু লাইভ এটা স্ট্রিমিংটা বন্ধ করো তো।
My lord, may I, my lord? Continue, my lord. Paragraph 34. From the above observations of the Supreme Court and the wordings of sections 13 and 14, it emerges that the rights of an owner of a sound recording are in no way inferior to those of an owner of copyright in the original or musical works. This was a proposition which was not challenged by either learned counsel. Then, my lord, 36. The three classes of work, I'm sorry.
No, all right.
The three classes of works referred to in section 2Y of the Copyright Act, namely literary, dramatic, musical and artistic works, cinematographic films and sound recording, kindly mark this, my lord, are mutually exclusive. As already noted here and above, 13.4 recognize that there is a separate copyright in the underlying musical and literary works which are embodied in a cinematograph, film or sound recording. Such underlying works do not lose their existence upon a sound recording or any number of sound recordings being made. Upon a sound recording being made, the three works remain mutually exclusive and the ownership therein can be exercised to the extent prescribed by the Act. As observed in para 3 above by us, when a song is recorded, my lord, this is again quoting my lord, the my lord dichotic my lord aspect of the matter. Then my lord, para 38. In view thereof, the argument predicated upon section 13.4 and section 22 with reference to the difference in terms of copyright in literary and musical works on the one hand and sound recording on the other, advanced by the learned senior counsel appearing for IPRS, which proceed on the basis that to hold to the contrary would result in merger in the sound recording of the underlying copyrights and hence lose their separate existence is incorrect. Then, my lord, kindly come to, my lord, English law, my lord, is considered. Then, my lord, we have, my lord, the my lord 77 Supreme Court, my lord, is also considered from para 50 onwards. And then, my lord, kindly come to, my lord, para 52. At, my lord, print page 25. My lord. The aforesaid observations relating to section 13.4 of the unamended Copyright Act made by the Supreme Court may be obiter. But we remind ourselves that an obiter dicta more so when it is with reasons in a decision of a court having higher position in the pyramidal structure must be ordinarily be followed by a court lawyer in the pyramidal structure unless there are very good reasons for not doing so. No good reasons have been shown to us by learned senior counsel appearing for IPRS, which would lead us to not follow the interpretation given by the Supreme Court to section 13.4. Now, my lord, kindly come to, my lord, para 53. We now proceed to examine the two decisions relied upon by the learned senior counsel appearing for IPRS. In the decision reported as IPRS, so-and-so IPRS had filed a suit before learned single judge of Madras High Court against Muthoot, FM channel, which had obtained license from PPL for broadcasting songs of members of IPRS, praying therein that Muthoot be restrained from broadcasting songs of its members till the time it obtains a separate license. While dealing with an interim application under Order 39, it was held by the learned single judge that IPRS has been prima facie able to establish that Muthoot has no right to broadcast songs of through FM without obtaining. In coming to the said conclusion, it was held by the learned single judge that definition of broadcast and communication contained in section 2DD and FF respectively show that broadcasting of songs by FM station involves communication of music to the public which is heard and enjoyed by them. The owner of copyright in literary and musical work has an exclusive right to communicate the same, and in view of such exclusive right of the owner, Muthoot has no right to so and so. The aforesaid decision was carried in appeal before a division bench. After noting that the license granted to Muthoot by PPL recorded that Muthoot has no right to use literary or musical works embodied in sound recordings licensed to it, and the legal position that the court has to only examine whether a prima facie case has been made out by the applicant while dealing with an application, the division bench dismissed the appeal filed by Muthoot. Notwithstanding that the aforesaid decision was rendered in respect of an application filed by IPRS and no way finally determined the controversy involved, we have examined the said decision and have found a fundamental fallacy therein. While holding that the owner of copyright in literary or music has the exclusive right to communicate the words to the public, learned single judge failed to note the rights conferred upon the owner of copyright in sound recording by section 14E, particularly his right of communicating the sound recording to the public. With respect to the argument of learned senior counsel appearing for IPRS predicated upon international convention, suffice would it be to state that it is settled law that unless an international convention finds itself legislated in municipal law, it would be impermissible to import the principle deducted from an international. In any case, if the legislature has legislated, the intention has to be gathered from statute, and while doing so, guidance may be had from international convention on the presumption so and so. And then, my lord, it goes on, my lord, to, my lord, uphold, my lord, and affirm, my lord, the decision. Now, my lord, this matter went to the Supreme Court. And my lord, this was, my lord, 2017, 11 Supreme Court cases. তুমি চলে যাও এখানে। Kindly take 2017 11 Supreme Court cases 437 দিয়েছো তো? My lord, kindly come to, my lord, by the time, my lord, the matter was taken up, my lord, by the Supreme Court, my lord, the amendments, my lord, had come into force. Now, my lord, the Supreme Court, my lord, kindly note, my lord, notes this aspect. My lord, in paragraph 16 at page 447. You would kindly see, my lord, 15 and 16. My lord, these are, my lord, assignment provisions. My lord, certain provisos, my lord, were added, my lord, in section 18, which I shall be placing, my lord, and paragraph 16, my lord, subsection 10, my lord, was added, my lord, by the 2012 amendment. Then, my lord, the above quoted subsection 10 of 19 is inserted with effect from 21st June 2012, which did not exist on the day the plaint was filed before the trial court in the year 2006. As such, rights as exist with effect from 28th June 2012 were not the same prior to it. Now, my lord, kindly come to, my lord, it affirmed, my lord, the division bench judgment at, my lord, paragraph 22, my lord. And, my lord, before that, my lord, paragraph 19 I need to show, my lord, 19 at page 449. A conjoined reading of various provisions of the Act leaves no doubt that though each of the 7 subclauses of Clause A of Section 14 relating to literary, dramatic or musical work are independent of one another, but reading these subclauses independently cannot be interpreted to mean that the right of a producer of a sound recording, who also comes under the definition of author under Section 2D5 and has a right to communicate his work to the public under section 14E3 of the Act is lost. It is nobody's case that the respondent defendants have stolen the lyrics or that sound recording is made without license from the lyricist or musician. The argument advanced on behalf of the appellants that the permission granted to the defendant was with sans the right to communicate the sound recording to the public cannot be accepted as there appears no such term and condition between the parties depriving the defendant from communicating his work of making song to the public. As far as international conventions and treaties, law has been amended by so and so. In the present case, the suit was filed and the law as it existed has to be applied for the period prior to so and so. And then, my lord, para 22. My lord, this is my lord. Kindly come to para 22, Millard. In view of the above settled principles of law and for the reasons discussed by us, we are unable to find any error in the impugned order passed by the High Court in the suit filed in. However, we would like to clarify that with effect from 21st June 2012, in view of subsection 10 of section 19, the assignment of the copyright in the work to make sound recording, which does not form part of any cinematograph film, shall not affect the right of the author of the work to claim an equal share of royalties and or consideration payable for utilization of such work in any form by the respondent plaintiff. This is, my lord, what is observed, my lord, by, my lord, the Supreme Court. Now, my lord, we come to, my lord, the 2012 amendment and how far, my lord, does it? Follow to me. Other side to যাচ্ছে না.
I'm just trying to, my lord,
My lord, I am, my lord,
influence Mr. Mukherjee to say, my lord, that we can stop here so that my lord can go, my lord, to the my lords can go to the farewell as well. My lord.
yes, I'm one.
Let's continue till 1 o'clock.
Very well.
We'll rise at 1.
I tried the vacancy. My lord, I'm making a reference, my lord, to the bill. My lord, for the simple reason, my lord, this was relied upon during the course of hearing, my lord, before the learned single judge, and the learned single judge has also, my lord, referred to this. Now, my lord, kindly come to my lord, page 14, my lord, which is the statements and of objects and reasons. Lord, one of the main problems, my lord, which was being faced, my lord, if, my lord, there was an assignment of the copyright, my lord, in a record earlier, my lord, one set of arguments was, my lord, that, my lord, what was contemplated was only records and no other medium of storage. So we started first with cassettes,
Correct.
my lord, whether it would cover that or not. Then, of course, my lord, to digital. My lord, the international convention said, my lord, no matter when, my lord, the copyright existed, no matter when it is assigned, my lord, it should cover, my lord, all other innovation, my lord, which, my lord, come into place, my lord, as a method of exploitation, my lord, of the copyright. So, my lord, if, my lord, there was a copyright, my lord, in, my lord, a record or a sound recording, then, my lord, it would extend to, my lord, not only the mediums of storage available then. My lord, today we are digital. We don't know, my lord, where we are headed. We could, my lord, go into, my lord, something, my lord, far more, my lord, modern than, my lord, digital. We could, my lord, enter the nano zones, my lord. We don't know where we are headed. So, my lord, even that would be protected. Because what was happening, my lord, was that, my lord, an owner of a copyright in a record or a sound recording, my lord, when it came to enforce, my lord, that copyright, was told, sorry, at the time that you executed this assignment, this was the only form of sound recording which was there. You cannot take it any further. So, my lord, there was international treaties, my lord, seeking to, my lord, extend, my lord, this, my lord, protection to all. I'm giving an example, my lord. There are several, my lord, innovations, my lord, which take place. My lord, this is, my lord, one. My lord, these were, my lord, included as part of, my lord, international treaties. In fact, I can show them, my lord, none of them dealt with, my lord, the right which is today, my lord, sought to be, my lord, urged. That, my lord, if I have a license, my lord, to, my lord, exploit a sound recording by communicating it to the public, my lord, from, my lord, the owner of the copyright in the sound recording, I still have to take a license from, my lord, the owners of the musical work and owners, my lord, of, my lord, the literary work. This is the issue here, my lord. Now, my lord, kindly come to, my lord, the statement of objects and reasons, my lord. My lord, kindly take the fourth line. The 1994 amendment was a major one which harmonized the provisions of the Act with the Rome Convention 1961 by providing protection to the rights of performers, producers of phonograms, and broadcasting organizations. Lordship seen, my lord, 37 onwards is broadcasting and, my lord, performers' rights. And, my lord, phonograms are, my lord, from record to sound recording. Earlier it was record. Then, my lord, it also introduced the concept of registration of copyright societies for collective management of the rights in, kindly note, each category of copyrighted works. The latest amendment in 1999 introduced a few minor changes to comply with obligations under TRIPS. My lord, trade related, my lord, this is. The Act is now proposed to be amended with the object of making certain changes for clarity, kindly mark this, for clarity, to remove operational difficulties and also to address newer issues that have emerged in the context of digital technologies and the internet. Now, my lord, I my lord, pause here. This was the purpose. Now, my lord, the two World Intellectual Property Organization Internet treaties, namely WIPO Copyright Treaty, WCT, and WIPO Performance and Phonograms Treaty, WPPT, have set up international standards in these spheres. The WCT and WPPT were negotiated in 1996 to address the challenges posed to the protection of copyrights and related rights by digital technology. Kindly mark this, Miller. Particularly with regard to dissemination of protected material over digital networks such as the internet. The member countries of WIPO agreed on the utility of having the internet treaties in the changed global technical scenario and adopted them by consensus. In order to extend protection of copyright material in India, kindly note this, over digital networks such as internet and other computer networks in respect of literary, dramatic, musical and artistic works, cinematograph films and sound recordings, works of performers, it is proposed to amend the Act to harmonize the provisions of two IPO internet treaties to the extent considered necessary. So, my lord, what was being really addressed? My lord, was, my lord, digital, my lord, technology, my lord. And, my lord, that protection which was available to these categories, my lord, musical, literary, dramatic works, cinematograph film, sound recording, performers, my lord, this protection, my lord, had to, my lord, come in. The WCT, my lord, deals with protection for authors of so-and-so, 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 photographs. WPPT protects certain related rights, which are the rights of the performers and producers of phonograms. However, India has not yet signed the above-mentioned two treaties. Moreover, the main object to make amendments to the Act is that it is considered that in the knowledge society in which we live today, it is imperative to encourage creativity or promotion of culture of enterprise and innovation so that creative people realize their potential, and it is necessary to keep paces with the challenges for a fast growing knowledge and modern society. And then, Miller, kindly see amendments proposed in the bill inter alia seek to, Miller, my lord, first is, my lord, the technological measures to owners of copyright holders, my lord, then provide exclusive rights and moral rights to performers, and, my lord, provide for definition of new terms such namely commercial rental, rights management information and visual recording, and to amend the existing definitions of the term author, cinematograph film, communication to public, infringing copy, performer, and work of joint ownership. Now, my lord, kindly come to, my lord, 8. Give independent rights to authors' literary and musical works in cinematograph films. And then, my lord, kindly come to 10. Ensure that the authors of the works, in particular author of the songs included in cinematograph film or sound recordings, received royalty for the commercial exploitation of such works. Now, my lord, kindly mark one thing. It is using the expression authors. And, my lord, royalty. That at the end of the day, my lord, the independent rights are being sought to be conferred on authors. My lord, I can tell your lordships, it's got nothing to do with, my lord, the two international treaties which are given there. It's over and above, my lord, let us say, my lord, what was there in the Act. There was some, my lord, further rights, my lord, to authors. Now, my lord, for what? My lord, author of song so-and-so, to do what, my lord? To receive royalty. For what? Commercial exploitation of such works. The such works, my lord, are, my lord, will be evident, my lord, from, my lord, the, my lord, Act itself, that, my lord, works, my lord, which, my lord, relate to, my lord, the musical work, literary work, and, my lord, dramatic work. Now, my lord, kindly come to, my lord, notes on clauses. The next page, my lord, page 16. My lord, the amendment to section 18, my lord, which is introduced, is being introduced, my lord. My lord, if your lordships just keep section 18, my lord, of the 2012 Act, my lord, next to clause 6. My lord, kindly see, my lord, the amendment starts, my lord, from, my lord, the second proviso. So, my lord, I'm reading, my lord. If your lordships look at, my lord, 18 is, my lord, what works may be assigned, etc. What period, how much of the work, whole, part, etc. Then, my lord, the first is, my lord, assigned. First proviso relates to future work. Then, my lord, kindly see the first proviso. Provided further that no assignment shall be applied to any, no such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at the time when the assignment was made, unless the assignment specifically referred to such medium or mode of exploitation of the work. So, my lord, let us say, my lord, I'm, my lord, the owner of the copyright. My lord, I have said you can, I'm assigning my right for you to use it only in respect of making records. Now, my lord, I might say later on, my lord, there is, my lord, other than records, my lord, there is another, my lord, medium of storage from which, my lord, communication to the public can be made. My lord, assignment doesn't cover it unless specifically provided. So the same, my lord, copyright, I might assign, my lord, to someone else, but not for records, for, my lord, another, my lord, storage. So, my lord, it's all coming in favor of, my lord, the owner of the copyright. Assignment has to be specific. If it has to apply to future modes of, my lord, storage and communication, it has to specifically provide for it. Otherwise, it only remains with records. So, Saregama, my lord, earlier had only for records. Today, my lord, that same, my lord, composer or lyricist, my lord, may give it to someone else for, my lord, another, my lord, mode, my lord, of storage and, my lord, communication. Now, my lord, kindly, may I just read on the clause, my lord? Subsection 1 of the aforesaid section provides that the owner of the copyright in an existing work or the prospective owner of a copyright in a future work may assign to any person the copyright either wholly or partially and either generally or subject to limitations and either for the whole term of copyright or in part thereof. Now, my lord, kindly. However, in the case of assignment in any future work, assignment shall take effect only when come. Now, my lord, the first, it is proposed to insert a second proviso to subsection 1 to provide that no such assignment shall be applied to any medium or mode of exploitation of the work which did not exist or was not in commercial use at the time when the assignment was made, unless the assignment specifically referred to such medium or mode. So, my lord, this is, my lord, one additional right, my lord, created, or a related right, my lord, created, my lord, in favor of the owner of a copyright. Then, my lord, the second proviso. It is also proposed to insert another proviso to provide that the author of the literary music or musical work included in a cinematographic film or sound recording shall not assign the right to receive royalty from the utilization of work in any other form other than as part of cinematographic film or sound recording, except to the legal heirs, etc. Now, my lord, kindly have a look at the third and fourth provisos, my lord. Provided also that the author of the literary or musical work included in a cinematograph film shall not assign or waive the right to receive royalties. So, my lord, a right has to be existing as on that date to receive royalties, to be shared on an equal basis with the assignee of copyright for the utilization of such work in any form other than for the communication to the public of the work along with the cinematograph film in a cinema hall. This is, my lord, as far as a cinema, my lord, film is concerned. Except to legal heirs, my lord, they, my lord, immediately, my lord, inherit. My lord, it's a intangible right, but my lord, heritable. Now, my lord, what is happening? My lord, by this, what is being said is, my lord, I wish, my lord, clause 6, my lord, was followed. But now, my lord, what it is doing, my lord, is, my lord, saying, my lord, that, my lord, if the person to whom a copyright has been assigned, my lord, he deals with it. So, my lord, kindly take a situation. My lord, copyright was existing. It has, my lord, been assigned, my lord, to X. So, X is the, my lord, assignee of the copyright. Now, my lord, the authors, my lord, would have, or the first owners of the copyright, after the assignment, as consideration, would have received royalties or, my lord, a lump sum compensation. Now, my lord, the assignee says, now I am dealing with this copyright. Consideration for that is the assignee will receive royalties. Now, my lord, the section, my lord, only says, my lord, that, my lord, it has to presuppose that, my lord, even in that royalty, my lord, part of it should go to, my lord, the owners of the copyright who had assigned in the first place. So, my lord, what is being used? Now, my lord, if it is musical work which has been assigned, the assignee, my lord, decides to deal with that musical work. The bundle of rights, what can be done? My lord, he says you make a film. Now, my lord, the royalty is to be received, my lord, by the assignee. That assignee, my lord, has to share it with, my lord, the original owners of the copyright. Because it says, my lord, the author of the literary or musical. Author remains, my lord, it's permanent. So, my lord, if he has done it, my lord, on his own, without, my lord, falling under any of, my lord, 17 ABC, he is the owner. Then, my lord, if he has assigned his copyright, he is no longer the owner of the copyright. But, my lord, he retains a right to receive royalty if the assignee of the copyright, my lord, deals with it. My lord, this is an instance of a cinematograph film. So the dealing has to be with the musical work and, my lord, the literary work, not, my lord, the cinematograph film. Kindly see the language once, my lord. Provided also that the author of the literary or musical work included in a cinematograph film shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of copyright for the utilization of such work where he is the author in any form other than for the communication to the public of the work along with the cinematograph film in a cinema hall. Now, my lord, kindly have a look at the second proviso, which is also relevant in our case. Because other than film music, my lord, there's other music as well where sound recordings are made. Provided also that the author of the literary or musical work included in the sound recording but not forming part of any cinematograph film shall not assign or waive the right to receive royalties to be shared on an equal basis with the assignee of copyright for any utilization of such work. Because Lordship recall 77, my lord, there's an assignment of the copyright in the musical work, assignment of copyright in the literary work also happening. So, my lord, for utilization of that work, when there is, my lord, an assignment made, or a license given by the assignee, whatever royalties, whichever way he deals with it. My lord, there has to be equal sharing. Except to the legal heirs of so and so. Now, my lord, kindly see clause.
Pause karo, live recording.